Roll your tape. Roll your tape. Governor is in the courtroom.
That's all right, just put the bill in. Do we have any legislators, Chair? No, I'm not going to sit. Okay, but the judges can sit accustomed that you are the workman that way.
Did I come to Albany to be abused?
These former erstwhile professors are always...
Thank you very much for coming. We're delighted to have the Chief and these other representatives of the Court of Appeals, Judges Alexander and Simons and Titone, and the Administrative Judge, Judge Bellicosa, with us today. This is an extraordinary occasion, an extraordinarily happy one. We'll be signing this bill in a moment. What the bill does, in effect, is to give our highest court, the Court of Appeals, a fuller opportunity to decide cases that are significant to the people of the state or that reconcile the differences that arise because of decisions that are disparate or at variance with one another at the appellate division level. People have tried to get this done for a long time. It's a singular achievement of this session that we're able finally to do it. And we're able to do it because many, many pieces came together. This was a challenging assignment, seeking to change the jurisdiction of the Court of Appeals. It would not have been accomplished at all were it not for the fact that the American Judicature Society, some time ago in the so-called McCrate Report, suggested this kind of narrowing, if you will, of the jurisdiction of the court. It wouldn't have happened if the new administrative judge, whom I had the great privilege of appointing as a judge, Joe Bellicosa, hadn't been asked by the Chief to come over to talk to our counsel, to talk to the Assembly, and to talk to the Senate. It wouldn't have happened if Judge Simons hadn't been involved with his own advocacy of the issue, and it certainly wouldn't have happened if the Chief Judge himself hadn't taken the kind of intelligent, aggressive, and reasonable position that we knew he would if he hadn't met with the legislative leaders and made clear to them the significance of this step to all the people of the state as they are impacted through the Court of Appeals. It wouldn't have happened if Stanley Fink and Warren Anderson hadn't wanted it to happen. It wouldn't have happened if they hadn't studied it, discussed it, debated it at leaders' meetings at which I was present. And so all these pieces came together. We didn't do exactly what the Chief asked us to do or even exactly what I proposed, but we got enough of it so that we can all regard it now as a substantial achievement, a good thing for the court, and therefore a good thing for the people of the state of New York. I want to express my gratitude once again to the legislators, and I will repeat, as I do almost every time we have this kind of opportunity to make a bill a law, that these things don't happen unless you have a small miracle here in Albany. And that is the miracle of the coming together of a Senate that's dominated by Republicans and an Assembly that's dominated by Democrats, the coming together of people from upstate and downstate, from rural areas and cities through their representatives, the coming together of blacks and whites and men and women, all the disparate elements that make up this complex society we call the state of New York. They all have to come together in those two houses to produce a bill. Even if it didn't survive the governor's office the first time around, it could be a law, as you know, because that powerful legislative body, by a simple two-thirds vote, could make it a law even over my signature. So the governor is a kind of relatively unimportant piece here because they can make a law without a governor. The governor can't make a law without them. And so I congratulate the legislature, I congratulate the Chief, I congratulate the judges of the Court of Appeals, I congratulate Judge Bellicosa, I congratulate them all for having the job I wanted. I envy them. I respect them. And I ask them now to speak through their chief judge, the one and only, the inimitable Judge Wachtler, Sol Wachtler. And I ask him not to do to us this time what he did to us last time, which is to be so brilliant, so scintillating, so humorous, so charming, as to make us, all of us, look drab and insignificant alongside of him. Chief Judge Wachtler, this is your last chance.
Thank you very much, Governor. I shall be as dull as possible. And that's very easy when you're talking about the jurisdiction of the Court of Appeals. I would like to mention one other person in that mix that the governor outlined with respect to the credit, and that is the governor himself, who, because of his great knowledge of the workings of our court, was able to take to the leadership meetings an understanding and a grasp and his own skill at persuading people, so that we were able to now bring about the first meaningful legislation that we've had in the Court of Appeals jurisdiction in the last 20 years. They talk about numbers. The United States Supreme Court has about 150 appeals a year and complains about the enormous volume which it has, and even talks in terms of establishing another interim court. The state of California, which is a state comparable to ours in many ways, although of course ours is far better, has about 250 cases in its court of last resort. And we had last year in the New York State Court of Appeals 711 cases, which gives you some idea of the numbers that we were battling. As a result of this legislation, we find that there'll be 350 civil cases which we would not have had except for being subject to certiorari review. So we have that kind of reduction and that much more of an opportunity to review those cases, to select those which are of greater significance, dealing with statewide policy and broader precedential impact. This allows for a reallocation of a very precious judicial resource, and that, of course, is something that we must all seek. And I, too, would like to thank, again, in addition to the governor, who, as I said, did such a masterful job in assisting us, Joe Bellicosa, who, as the chief administrative judge, was on the point, working with the legislative leaders in framing the legislation. I'd like to thank Speaker Fink and Warren Anderson for the excellent job which they did in their respective houses, Jerry Crotty and Pat Buckland working through counsel's office, who did such a wonderful job in helping us, and of course my colleagues on the court who were ever supporting in this effort. Again, I would like to thank all of you for being here, and again, Governor, so much for giving us this opportunity of saying thank you to all those people responsible for this very important move. Thank you.
I give you sip. Will you join us in the picture? This is no mock signing, Chief. This is the real thing.
You know that was pretty dumb.
Chief, yeah. How was that dull enough? Look down at the bill. Don't look at the cameras. I'll look. Okay, we ready? You're good at this, Peter. Button your jacket. There's no telling what you guys will do with it when you get it. Okay, great.
That's right, John.
Congratulations, Joseph. Thank you very much.
Thank you.
Okay. Let me just see if they have any questions on this. If not, you have one. I just want to show you the chamber. Have you seen it? Yeah. Do you have any questions on this? I'm only going to take questions on this because I want to walk down to the executive chamber with the judges and show it to them. If you have other questions, I can answer them in an hour or so. How about on this bill? Sure.
We had 711 appeals last year. 350 civil appeals came to us as a matter of right, which would not ordinarily and will not ordinarily come to us, under this bill would not have come to us unless we grant certiorari. And as far as the other states are concerned, there's 150 in the United States Supreme Court and about 250 in California.
Those totals are criminal and civil?
That's correct.
Good. If the law works the way it's supposed to, how many appeals would you anticipate you'd have next year?
There's no way of knowing, but I would say that considerably less than we had this year. Of course, of those 350, a great many will come to us anyhow, but again, there'll be cases of relative significance as far as the state is concerned.
Okay. Why don't you, if you have any other questions, any of you, I'll be at the executive chamber 10, 15, 20 minutes, tops, okay? See you there, and I'll answer them then. Thanks.